Mr. Lahr, opening statement for the defense.
Morning. In Washington, D.C., there's a building, and it's called the National Archives. If you go into the National Archives, you'll notice that there are a bunch of documents that are really important in our nation's history. Declaration of Independence, the Magna Carta. You'll also see the Bill of Rights. And the Bill of Rights, if you looked at it, you'll notice that it's kind of old and fragile looking, and that the writing's faded. But what's interesting is while this document is old and faded, that the principles that were espoused in that document stand strong today, particularly the right to be tried by a fair and impartial jury. Over 200 years ago, our founding fathers recognized that in order for us to maintain our freedom, that we could only do that if we were able to, again, give that right to a fair and just trial for everyone who's been accused of a trial. And the only way that that's done is to go through the thought and the principle that every person is presumed innocent until and unless the state proves that beyond all reasonable doubt. Now, we began this case 2 weeks ago with Judge White starting off the trial, saying in the United States and the great state of Florida, a trial by jury is fundamental to our system of justice. Without people like you, our jury system would fail. And other than voting, serving on the jury is actually the most important opportunity that citizens get to participate in the democratic process. Now, you know, we've picked this jury after 2 long weeks, and I'm sure there were a number of you very frustrated sitting in the back waiting to come in. It was a very long and tedious and laborious process. But it's something that we have to undertake. It's the process we undertake in order to make sure that we arrive at a fair and impartial jury. And there is one thing everyone on this side of that bar know at this point. You were selected because we believe that you would be fair and impartial. And that means, of course, being fair and impartial, that you will follow the law. And that would mean that you have to make sure that the state proves this case beyond all reasonable doubt. He is not guilty unless you all find that that the state has proven this beyond all reasonable doubt. And why do we do that? Because, again, we're a nation of laws, and we all agree to follow that. So, again, the state has to bring that evidence. So how are you going to make that determination? Well, the way you're going to make that determination is by listening to what you hear from this spot right here. Nowhere else are you going to hear any evidence in this case except from right here. And that's where you've got to derive it from. What I ask you to do is this. As you are hearing witnesses, listen very closely to what they tell you. You all have the opportunity to have notebooks, to write notes down. To be able to determine what things are important to you in making that determination. After the state asks the questions, we get the opportunity to do a cross-examination. Again, listen very closely to those things, because that's where you're going to make the ultimate determination whether or not the state has proven its case beyond all reasonable doubt. So as you're listening to these things, and we'll eventually later come before you to explain why he should be found guilty or not guilty, I would ask you just to pay very close attention to what you hear. Listen to consistencies, inconsistencies, and those things. Because if you follow the instructions of the law as it's set out, then the process that our founding fathers set up 200 years ago will be fulfilled. And that will make this country free. We have followed these rules, and we sit there and we agree to follow those rules.
Could counsel approach?